Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dahil mihi Anglican po, he's verbis Latinos. I didn't ask you to interrupt me.
Is that correct?
Oh, for crumb's sake.
I forgot to turn my camera on. Okay, give me a minute. I'm here. I promise I'm here. Let's just. There we go. All right. Oh, that was funny. Good morning. How's everybody doing today? Happy Tuesday to you. Send someone with a lot more experience. Why is the audio so low right now? Did I do something to...
Hello?
Maybe it's just the music's just covering everything up. The music's just too loud. What do you think? All right, let's see if everything else works. Kim, congratulations. Kim R16, you were first in chat. For your promptness and punctuality, we're going to punish you, and everything I pay related is your responsibility. But you should do fine. You're fine. I don't know why the sound effects are so quiet. Because the music was plenty loud. But go figure it out. Speaking of figuring out, guess what I didn't do last night? I didn't figure out how to use my new equipment yet. What is that photo on the phone? This is Mod Chat. Don't look at that. Don't look at Mod Chat, Josh. We know you don't read it anyway. It's Terrific Tuesday. It's amazing. It's amazing. We're excited for that. All right. Yes, congrats on Grandson Red. That's awesome. We're super, super excited. Speaking of Red, oh my goodness, Red just gifted not 20, but 25 gifted memberships this morning. Congratulations. If you find yourself in green this morning and you weren't yesterday, it's probably because of Red.
I'm not going to argue about semantics here.
Semantics. Let's see. Good morning, Blair. Good to have you here. Trying to figure things out this morning, and I've got to say it's not working very well. We're hoping to go back to court in Texas, which we liked yesterday. We saw that some jury selection. We'd like to go back there and see how they're doing. It looks like they're setting up for other docket work, which means we don't know when the trial's going to start. So that's because I lost a bet to Amber. What was your bet? Was there a bet in Mod Chat that I didn't read? Probably. Let's see. That's my way. Okay, I can't tell you what happens in Mod Chat. Okay, let me just out this before the mods do. Before the mods out me. Ready? Last night, one of my mods, who shall not be named, was playing on their phone or put their phone in their pocket or something. I'm not sure who. I don't want anyone to think it was one person or another. But it was late. It was after 9 p.m. What time was it? Was it 11 p.m.? I forget. It seemed late. And I'm getting ready for bed. I'm getting the changing part of getting ready for bed. And as always, I have my phone with me, and the burner phone goes off, or at least I think it's the burner phone. I'm like, hey, I answer the burner phone. I just do. This call was different. It was from a mod. It was a mod raising the all hands alert, call everyone. Not just call everyone. Video call, everyone. Let's get that two-way communication going by default. Not like, oh, I think I'll turn on my camera. So here's me thinking I'm about to pick up a burner phone call, getting ready for jamma time. Not yet in the jammas. I think this is clear enough. I don't have to paint a better picture. And suddenly I am face to cheek with all the mods, or at least all the ones who could bother to pick up. Amber, who initiated the call, did not. So I hurriedly turned my camera off, and I apologize for anything anyone might have seen. There we go. I've outed myself, and now I can no longer be blackmailed by that bit of information. All right, Samantha, Thomas, I'm so sorry. I'm so sorry. They were the two prompt people there. Anyway, how are you guys doing this morning? I hope you're doing absolutely wonderful. It's a beautiful day. It really is a beautiful day. And, it could be worse. What can I say? It could be worse. It was cold, says Greeners. All right, Ricky, good morning to you. Thank you, RA and mods, for all you do and don't do. Yes, Ricky, thank you very much. 33 months makes you an OG. Appreciate you, Ricky. All right, we're... Is it Friday yet? It feels like it needs to be Friday really quickly. Mrs. RA is gone. She's gone for most of the day. She's taken some of the kids with her. We're doing two things. Well, when I say we, I say she is doing two things. She is, number one, taking our broken windows, 3 of them, to the window repair place to hope that they're able to actually repair these 115-year-old window frames. That's all there. So that's the first thing. Number 2, she's buying a car. Now, we sold our other car. We're down to 1 car. We're a 1-car family right now. And we're going to do birthday things in just a second. I'm giving all the latecomers time to notify the mods. There we go. Thank you. She's buying a car. I look at this much like she probably looks at me buying a house. I have no idea what she's going to come back with. I don't even know if I'm going to fit in it.
Hello.
Because I'm tall. But she's headed out to buy a car today. So wish her all the luck in the world. And we'll see what we have later today, or whenever we find one.
Hello.
We sold Chip. And we got exactly what we asked for it, which was a good price. We asked for $500 below low book, which accounts for some of the aftermarket features it has. All right, the problem is we now have to find a car that matches with Sahoy, because Chip and Sahoy were a team. But what do you name a car that pairs with Sahoy? So, all right, let's get ready for the birthdays here really quickly. I'm sorry, I've been distracted this morning. Excuse me. All right, wherever you are. If it's legal and you're able, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. That'll work. Emma, Fulva Mom, Isabella, Linda, and Suzanne K. Happy birthday to you. Happy birthday to you. Happy birthday, dear Emma, Fulva Mom, Isabella, Linda, and Suzanne K. Happy birthday to you. Greeners, yes! We need Matey. We need Matey and Sahoy. Sahoy, Matey! It's got to be a pirate name. That's awesome. Let's go back to the birthdays, though. I'm sorry, but we have to finish celebrating. Emma, Fulva Mom, Isabella, Linda, and Suzanne K. Happy birthday. There are many wonderful days, but today is your special day. And I realize there are a million places you could be and a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy, that's ours. But hopefully we can turn it back to you and make your day a little more special. Or begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlop's House, Andy's Grill, Bob Evans, and Cracker Barrel. Woo! First try. Ann Watson, welcome to the gallery. Thank you very much. OG. I'm pretty sure you're an OG. Look at that orange courthouse color. There we go. What a way to start the day. I'm just jamming to the music, sorry. What's this trial about today? Well, if we ever get started in this trial, which is, you know, I think it'll happen. If it ever gets started, we watched jury selection yesterday. It was pretty good. We'll keep an eye on it.
Happy birthday. You look good.
Judge Fleischer, thanks for weighing in. Appreciate you, my friend. Hope you're having a great day, sir. Also down there in Texas. Sticks out, says Red Pen. If you've never played the air drums, today is a great day to start. You just grab them like this, and you do this. Snares on the left hand. Greeners asks, can we listen to the song She was selling more than vacuum cleaners? Okay. Greeners suggested this yesterday. And the answer is no, and let me tell you why. I didn't know what they were talking about exactly. Like, I think, was she dealing like narcotics or something? I had a suspicion that it might not have been, you know, on the up and up. So I went to Suno, and I gave it probably the least guidance I've ever given a song. I said, write a song about a Texas lady who was selling more than vacuum cleaners. And apparently AI knows exactly what that is referencing. And none of them, they're all like NC-17. I cannot play them on the channel. We would get struck and people would, whoosh, they were bad. Apparently it's not drugs. So that, I can give you that. It's not drugs. So no, Greeners, we can't. It's naughty. I still don't know. I'm not afraid to ask you. I can't even link it to you in mod chat, Greeners, unfortunately. So yeah, it's yeah. I made 4 versions in case AI was just guessing wrong. Each one got worse. Let's see. AC's Wildflower. Working on my son's senior slide now, so I changed up my YouTube pics. If you squint, you can see my baby who's all grown now. Oh, cool. Look at that. There he is. We'll put him right over here for a minute. Looks like he's out on the water, enjoying a day at the lake. All right. Where are we? Well, here we are. Let's take a look at this court because it might be starting soon. But I'm trying to. Does anyone have the docket for Raquel West? Does anyone know what the docket lineup is for today? Because if they have like 2 things to do before trial, then that's cool. We can handle that. But I'm just looking in there. We've got too many people in the audience. That's a lot of court watchers. I don't think we have the same jury. Look who's here. So nice for you to show up. Let's go ahead and clock in. No, just kidding. Is that our defense attorney? I think that's our defense attorney. We may be, I think we are. I think we're still in jury selection. That's it. We've got to still be doing jury selection. Don't recognize the big attorney in light blue. The guy in tan on the right, I think he's the defense attorney. He's sitting on the defense table. But there's a lot of people here. More than I'd say is normal. And then we've got a fair number of people coming in, sitting in the gallery, which I believe are jurors continuing their quest to be released from jury service. We watched pretrial yesterday before the trial starts, and I'll grab the docket. Yeah, let's try that. 1 hour, 52-minute mark from yesterday. Yes, they're docket items before trial. Sounds good. Let's watch pre-trial. That'll help us understand a tiny bit about what is actually happening in this. Let's see. We need this one. Pre-trial, right? Let's go to 6 over here. Nope, not 6. Six should work. Why did 6 not work? Camera 6. There we go. I hit the wrong button. All right, yesterday's pre-trial. Is it 17 hours? Hey, Josh, is it the... we've got 2 from yesterday. $152. See if this is it. I think this might be it. Let's see if
which is
this
between
is the right
2
one.
years and up to 10 years. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your
You're
right
just
to
wrapping this one
appeal.
up.
You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork.
This can't
All right,
be
good luck
it.
to you, sir.
This can't be it because we've got jury members in
Christopher
there.
Stiles, it's a sentencing, Mr. Galmore.
This can't be it. Let's go back to live. Josh, it's got to be the other one. And what time did you say, Josh? Hang on, hang on. $152.
And this is 25 DCCR 0594. Mr. Stiles was previously in court, entered a plea of guilty to the state jail felony offense.
Still not it. Okay, we're trying to figure this one out. And by we, I mean me. I'm the one that's in the dark here. 1 hour, 52 minutes.
Have them send someone with more experience.
I just don't know which. I need to know how long the video is to know which one it is because I can't click on the link. Okay, let's go here. This looks a little better. Pre-trial stuff. They're facing the right direction, facing the jury. They're getting set. The jury's not here yet. We've got 3 Heinekens on the defense table. Did Heinekens? I forgot to check. Red, did Heinekens make it into the? Not yet. We don't have Heineken on there. So this is it. Thank you. In the future, Josh, I can't click on a link for Mod Chat and pull it straight up. I have to literally find it separately on a different device through search. So if you can tell me the time, like how many hours, minutes, and seconds the whole video is, that's the easiest way to find it. They sure can be on the thumbnail. He does have 3 cans of, I don't know, it's probably Sprite or Starry or something, but they look sort of like Heineken. Audio was not on this part. We're waiting for audio to be turned on, probably when defense lawyer gets involved. Need a fan on the thumbnail. Oh, there's a fan on the thumbnail. We have bacon, orchids, the defendant, the fan. If you guys missed our Ohio case yesterday morning, holy cow, what a doozy. Just a morning case, covered the entire thing. Bench trial, so no jury instructions, no jury selection, no deliberation. As a matter of fact, we barely even got a break in the trial. But had 5 or 6 witnesses get called, and let's see if we can list everything that happened in the trial, like bingo type items, right? Okay, we had jail calls with the defendant trying to collaborate with the co-defendant. We had issues with witnesses, prior drug use. Pretty much everyone had a record that was there on all sides.
Walmart.
We had defendants or witnesses breaking the rule of sequestration, and defendants talking to witnesses in the hall during the break to tell them, I don't know what to say and things like that. We had people lying for sure, 100%. I won't say who. You can determine that on your own. And I think number 5, I think we had a judge who wasn't paying attention. I'll put that out there as well. That's what I came to yesterday. It was no police testified in that one. We need more vacuums on the thumbnail. We had the vacuum thing, yeah. But that's in this court, not in the Ohio one. It's getting crowded up here. That's a cool little folder. He's got a little leather bound binder. Defense attorney's getting all set up. That's his go bag. Wipes a little sweat from his brow, says, is it hot in here or is it just me? She says, I can turn it down, but it says 70. It's like, it's all right, I'll just sit here in front of my fan.
Okay, let's go on the record. Mr. Coleman and Mr. Wilkerson are here. And sir, you're Romeo Johnson?
Yes, Sean.
And so, Mr. Coleman, Mr. Wilkerson, are you both ready to proceed with trial?
State's ready. Vince ready.
And we are going forward in 25 DCCR 1626, the unlawful possession of a firearm by a felon, correct?
Yes, Sean.
And are there any motions? I know there were some issues we had before where we were ready for trial, and there was some request to use the transcribed testimony of the defendant, and then there was another witness who was out of town. Any issues?
I think that's not the case this time around, Judge. I did file a standard motion in limine. The only thing I'd like to add to that motion in limine is any reference to the acquittal or not guilty verdict in the murder trial.
Your Honor, the testimony.
Hold on just a second. You guys are free to go. Thank you.
Thank you, Your Honor.
Your Honor, the testimony that he seeks to introduce is directly from that trial. The jury not only deserves, but is entitled to the context in which that testimony was provided, as well as the outcome.
That's my brother.
I don't know about the outcome. I don't think that is relevant. I think that would be, I don't see how, if it were either way.
It's relevant to motivations for the underlying charge here, Judge. And if the court recalls, we have a motion for speedy trial filed on the aggravated robbery case, which we're going to be seeking to dismiss if we are moving forward on this case, because obviously if the aggravated robbery were tried and he was acquitted, he would be able to make bond on this charge. Whereas if he's acquitted on this charge, he will remain in custody.
So let's take that up at the appropriate time, which will be as soon as this trial's over. So we'll move forward with the unlawful possession of a firearm by a felon. Depending on the outcome of that, I would anticipate that something would happen very quickly with regard to that aggravated robbery. If not, I would obviously consider a bond reduction based on all of that. I do think, though, so you still intend, Mr. Coleman, I want to make sure that the testimony that you are intending to introduce from that prior trial, you're still intending to do that, correct?
Yes, ma'am.
Okay.
Carving out any reference to a murder, my plan is to refer to that proceeding as a prior proceeding. I don't know. I'm open to any suggestions from the court how to refer.
So my position is going to be that we are not getting into going down the rabbit hole of what that was, and for sure not what the final verdict was in that case. I don't see how that would help do anything other than potentially prejudice this jury.
Just for record purposes, regarding that prejudice, Your Honor, the introduction of the testimony from that case by referring to it to a prior proceeding, especially when testimony is being used as an admission of guilt, is in and of itself prejudicial. So I understand your ruling and we will abide by it, Judge, but obviously our assertion is the complete opposite.
Sure.
And we also believe that this case was motivated by the acquittal and intended to show such, Your Honor.
This case being
the unlawful possession of a firearm by a felon, as this case was not filed.
Well, I mean, I'm not going to get into what the state's theory or reasoning to file whatever they filed. They have filed it. It was indicted by a grand jury, set for trial. We're going to trial. We are going to go to trial on that unlawful possession, and immediately at the end, depending on the outcome, bring back up any issues with regard to the older aggravated robbery. We'll get that taken care of at that time. And I'll hear any motions on that. With regard to the notice of intent to introduce the transcribed testimony, we kind of went through that before, I believe, when we were set to go, and then I don't remember exactly what happened, but we didn't go to trial. And my interpretation of 804, I think it's B1B. Anyway, I believe Mr. Coleman is entitled to introduce that. It was from the same criminal episode. So it's not some testimony, from some other case that has nothing to do with these particular facts. And so for that reason, I am going to allow that testimony, the transcribed testimony. It is only going to be limited, however, to the prior hearing, and not that it was in a murder trial, and not that it was for sure an acquittal in that murder trial.
And just, I am referring to the excerpt, and it's just an excerpt from my questioning of the defendant. It's like it's 6-page excerpt, yes. And I'm happy to give it to the court if you want to preview it afterwards or during a break. But it's just an excerpt of me essentially asking him about the firearm.
Okay.
Your Honor.
Yes.
I'm trying to understand why, when a defendant testifies, the state can examine that defendant about their criminal history, but that if a defendant testifies on his own behalf, he can't talk about his criminal history.
Hearsay. Self-serving statement.
If your client chooses to take the stand in this case, then I would think there would be probably different, and that he can say that he was charged with something, but it's not a conviction. And at that time, I think I would want to take that up before that question is asked, and let me kind of think about it and do a little more research on it. Because if somebody's been charged with something, acquitted of it, again, how does that then become relevant or help this jury determine guilt or innocence, is what my thought process is going to be. I'm not going to prejudge that right now, but I am saying right now, before
is he alleging malicious prosecution?
Question any witness about the prior trial that ended up in the acquittal, you approach the bench and we discuss it outside the presence of the jury, regardless of any motion in limine. I'm making that order at this time.
I'm sorry, go ahead.
I'm sorry. I would note, Judge, just finally on that matter, that in terms of the state being able to use uncharged offenses that have not, where no guilt has been determined, both in guilt innocence as impeachment evidence, if the jury finds beyond a reasonable doubt that that act actually took place, and the state's ability to introduce testimony on uncharged acts and omissions during punishment. That again, it would re-urge the question that
again, I'll take it up at that time to see but they're not just allowed to do that without certain findings by the court, certain requirements as to why they are admissible. And so the same, I think, would apply as to the relevancy of it. And we would get to that if, in fact, he decides to take the stand in this trial. I would have to decide that at that point. But they don't always get to do that depending on what it is going to show, motive, intent, preparation, identification, and all of those laundry list of things. And it doesn't always have one that applies.
And again,
Right.
I think I'm referencing a defendant's own testimony more so than the enumerated reasons for allowing other extraneous acts into evidence. But those used for impeachment purposes as far as the witness's credibility. And so,
well, I mean, but the state's never, not that I know of, has the state been able to go into something that for credibility or impeachment for a charge that was either charged and dismissed or charged and acquitted. Certain specific instances of some type of behavior maybe could become relevant and admissible. But if there is, it's almost the negative here. There isn't one. It was charged and it's gone. It was acquitted. And so that's, I guess, it's kind of the...
And I just want to put a point on that, Judge, is with regard to the murder, that's a whole separate offense with separate elements. We are proceeding on a new offense with separate elements, Judge, and the potential here is not only to confuse the jury, but also to open the door and allow improper argument. That argument being, because he was acquitted of this, he should be acquitted of, because he was acquitted of that, he should be acquitted of this as well.
Which is the exact same thing when it's the other way around. You can't say he must be guilty of this because he already did that. So we don't allow the state to do that. And so I don't think it's fair to do the opposite of that, if that makes sense.
I think where no, that makes sense. And I think where it'll become relevant is if the defendant takes the stand and there's some sort of use of prior bad acts to impeach his credibility as a witness. And so,
well, yeah,
I guess
but
we'll cross that bridge when
yes,
we come
we
to
will.
it.
But I want to know, so before, if he is going to testify, then we're going to take some time, because I'm going to want to know exactly what potential bad acts. It's not going to be the murder. The murder was acquitted. So to me, for all purposes, the murder is outside the scope of whatever is going on here, other than the fact that it's the same, again, criminal episode. He testified, made some potential admissions that I believe and have already made a ruling are admissible in this case, but we're not going to get into the confusing part of the acquittal and use that to potentially try to sway a jury to say he was found not guilty of that by another jury. So this jury should do something in line with that on this case. So I
don't anticipate ever making such an argument, first of all, but I do anticipate introducing testimony from the defendant and as to the fortuity of the alleged possession of a firearm in this case, which again was that testimony was provided and tied to an examination of the witness based on the allegations at that time. But again, I understand the court's ruling.
All right.
One final thing, if I may, Judge.
Yeah.
Just so we're all on the same page, are we referring to that prior case, the prior trial, as a prior court proceeding? That's
yes.
what I'd like to refer to it.
Hearing or court proceeding,
okay.
Either one. I think those could be used interchangeably. If you accidentally say hearing, it's fine. Court proceeding is fine. Trial, not fine. And trial of murder, definitely not fine. So with regard then to the state's motion in limine, that has been on file, Mr. Wilkerson, have you had an opportunity to review that?
I have,
Standard,
and
do you have any
it's pretty
objection?
standard. The only other one that I find objectionable is the one that we pretty much discussed. It's at the bottom of the second page. Additionally, there may be some evidence introduced of another pending charge, but I guess we'll have to deal with that at the same time as well, because I mean,
I think he's talking about the aggravated robbery.
Yes.
Yeah.
Yep.
In the guilt innocence, do you anticipate that being an issue at all?
No.
Okay,
No.
so that there's no reason for that to be brought up in the guilt innocence. Now, if the defendant takes the stand, we can take that up outside the presence. It sounds like if the defendant chooses to take the stand, we'll obviously need to kind of regroup with regard to any other witnesses in the guilt innocence. I don't see anything that would make me feel like any talk about the aggravated robbery, definitely that underlying murder case that was acquitted, anything not convicted. It is an unlawful possession of a firearm by a felon. So obviously the fact that he's been convicted of a prior felony is relevant. So we can't get around that with this type of case. So that obviously is jurisdictional, and the state will be required to prove up that in the trial for guilt innocence, which is a little bit unusual, but required in this one. Other than that, anything else then? I'm going to grant the state's motion in limine. In addition to what I've kind of ruled on with regard to discussing that prior trial, and anything that you think becomes potentially relevant or admissible, approach the bench first if you think some door's been opened or something like that.
Before we start, I need some instruction on the questioning of the detective. Because one of the questions that I intend to ask is the nature of the investigation. So essentially you're telling me I can't ask him about the nature of the underlying investigation. How do I talk to him about when this case was finally indicted versus when it was investigated, and then along those lines, why it was investigated?
May I propose that and of course, the court can make the ruling the court decides to make. But I mean, certainly he can ask the detective if there was an ongoing criminal investigation. I don't have a problem with that. Whether or not this defendant was subject to a criminal investigation. It's just a reference to the murder and any reference to an acquittal.
So he has no problem. Essentially, this is what I'm hearing. You can say that there was an ongoing criminal investigation. You just can't talk about the fact that he was acquitted in that investigation.
Correct.
Yeah, you're the one that's wanting to ask him about the nature of his investigation, and I will concede I don't see a problem with you asking him whether or not there's an ongoing criminal investigation.
I don't either. But here's the thing: what's not gonna come in is the outcome of that trial. So if you want to question, I think it's fair. I don't disagree that it's relevant potentially that why they were investigating, and they were investigating a murder. They were investigating an aggravated robbery. But I'm also not going to allow you to go down the path very far of what's the outcome of that and what's happened. We're here on this case. Those cases, just like I would tell any jury, are set for another day, another time, another jury. That's not what we're here for.
Can I talk about the fact that a different defendant was charged with that underlying investigation?
I just don't think that becomes relevant or helpful for the jury. My ultimate question, obviously, on relevance is how will that help this jury determine if this defendant is guilty of unlawful possession of a firearm by a felon? And so it's going to be very limited on how far I allow you to go down that path. Talking about co-defendants and what they were charged with and what's happened on those cases doesn't matter. If it was the murder case and there's a co-defendant to the murder, absolutely. But it's not. That's not what we're here for. It's a very limited requirement as far as the indictment is what it is. Whether he was in possession of a firearm is the question. And muddling it up too much with all the history is not going to help this jury. So I guess that was a long way to answer no. We're not going to talk about the co-defendant and what anybody was charged with. You can talk about that they were
conducting
an investigation.
But
and in the process of that investigation, I mean, by the time you're questioning him, my guess is the video's already going to be in. They're going to already have seen the video of what happened and in person, you know. And so what we're talking about, just because I've obviously seen it in that trial, is on video. And so the jury will have already seen that. And so going down any other path very far, other than saying either you did or didn't see what you saw, or what was on the video, you interpret the video however you interpret the video, whether or not he possessed a firearm or didn't. There's going to be the testimony that he gave previously. And so I think that limits it.
You heard Mr. Wilkerson also mentioned the timing of how the charges and when the charges were filed. I would object to that, Judge, just so long as it's within the statute of limitations. That should have been the subject of some form of a motion to suppress.
No. So the indictment that's going to be read to the jury talks about when the indictment occurred. Obviously, it also talks about
the date of the indictment.
No. In the term assembled.
Right.
I have no objection to that, Judge.
And so I should at minimum have a right to cite the portion of the indictment that talks about when it was indicted versus when it was investigated or committed.
I don't necessarily have an objection to that so much as there an argument that for whatever reason there's some nefarious or malintent on the part of the state, Judge.
Yep.
Well, because we're not going to get into the murder and the outcome of that murder, it again does not. I understand where you're going with this. They didn't get a guilty in one, so now they're going to file something else.
Yep.
How's that going to help this jury knowing that?
Knowing that the offense.
How does it help them determine if he's guilty or not guilty of this charge? If you're trying to get into, well, they didn't, it didn't work on one, so they're trying something different.
It showed whether the prosecution believed that there were grounds for this charge in the first place, Your Honor.
Because we routinely exercise prosecutorial discretion in bringing charges, and we make that call all the time.
And
that's a call. I guess the issue with that, I don't know that the detective had the ability. He didn't make that call. It was the state that took it to the grand jury, and
we exercised our prosecutorial discretion in this case, like we do in many, many other cases, Judge.
But how does the detective testify to that? I guess is if
you'll see.
All I can elicit from the detective, and all I intend to elicit from the detective, is the date of the underlying occurrence and when it was indicted.
No objection.
Now, in terms of argument, citing that date, the delay, and the recent indictment of a case, I mean, that's something that.
I mean, you can argue the dates, but not argue. We're not going to again get into, well, they didn't get it. You're not going to be able to bring up, we're not talking about the murder and the acquittal in the murder. So knowing that, I guess you limit yourself to whatever argument you can make on that. Because I just don't see how that is relevant to helping this jury determine guilt or innocence of.
He's trying to prove malicious prosecution.
Whether or not a grand jury that considered the occurrences in the prior in this.
We don't know what a grand jury looked at, and we're not able to know. So we don't know what was presented the first time around. We don't know that. I don't think. I mean, we're not going to have a grand jury here to question, and the detective sure isn't going to be able to answer that question.
Obviously,
from a grand jury,
there had to be an allegation of possession of a firearm in order to.
But that's an assumption.
So
yes, I agree that at some point there was, but I don't know. We don't know what the grand jury, why they did what they did, why the state did what they did. And I don't think it's relevant to this jury really to know those things. I don't think it helps them to determine the guilt or innocence of. I mean, you can be unhappy about why it got to this point. I get that. I understand your reasoning and the frustration, but the charge is what the charge is. If it's either guilty or not guilty of this charge, fair or feeling or not fair feeling to you and your client. It's what the grand jury indicted him for, and we're going to limit it to what will help them make that decision in this case.
So can I ask the detective why he thinks it took so long?
That would be pure speculation on the part of it.
I mean, you can ask it if he objects at that point based on whatever evidence has come in. I'm not going to prejudge that. So, I mean, ask the question and then if there's an objection, I'll determine based on what I've heard at that point, whether or not I would rule.
I just don't think it would be speculation for him to answer.
Well, we'll get to that at that point.
All right.
All right. So
there's going to be at least one objection in this trial.
Granting that motion. Anything else before we get the jury seated?
I from the state judge, as far as time, I can't imagine more than 30 minutes. Pretty good.
Okay. Mr. Wilkerson,
warning.
you're fine with that?
Yes.
What warning to 5 minutes?
Yes.
Okay.
All right. That was the pre-jury selection fight that we missed yesterday. I wanted to show you that. Right now, the judge is actually, if we jump back to real time, is handling some other court docket stuff while we wait for this trial to start. And I think Josh was trying to pull together the docket to see what the schedule is. Let me see what that is. Okay. Here's the docket. Let's jump to live.
It's this fee plus that fee. So total in both cases, Your Honor, will be around $550.
What I'll do, let me make a notation and I'll get with Ms. Werner, the other clerk, and find out exactly with the process for that, and take into consideration that he's indigent, that you've relayed that, and I will let you know exactly how that works and if we can do it. Do you have any issue with regard to that?
I'll defer to the court on that issue.
Okay.
They have their backs to us
All right, you
because
can go
we're
back to
choosing a
bailiff.
jury.
Yes, sir.
Have a good day.
You'll make a note on me on that, please.
The jury's going to be seated there.
Mm-hmm.
All right, we might pop into another court just while we wait for this to come around. I know Judge Dad is going right now. If you want to see him. Let's see.
Mr. Lewis, you have Daryl Burnworth.
Yes.
Yeah, we've got a few people. Let's jump to Judge Dad real quick.
Good morning.
Good morning.
And that's that, but you're going to pay $35 for court work program, attend 1 day on the court work program, pay additional costs of $75, continue testing bi-weekly until August 15 of 26. If you're clean, I'll then make it monthly. Okay? We understand one another?
Sorry.
Good. All right. Anything else?
Nothing from Your Honor.
Thank you very much.
Thank you, Judge.
Have a good day, sir. Good luck. Stay out of trouble.
That's a good luck. Stay out of trouble. That's a good soundbite.
People against John Lawrence Wood, 26M703-415 FY.
Why are the people against you, sir?
Good morning. Trooper, your name?
Trooper Brown, Michigan State Police.
Good morning, sir. Sir, your name? Your name?
John. Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf.
All right. So, for purposes of, he is charged with a felony charge of possession of cocaine less than 25 grams a 4-year.
The people don't.
Does he stand mute, wait formal reading?
Yes, correct.
All right, so I'm going to enter a not guilty plea. I'm going to advise you of your rights, sir. You do have the right to remain silent. You do not have to say anything. If you say something in or out of court, orally or in writing, it can be used against you. Do you understand that?
Yes, sir.
You have the right to be represented by a lawyer today. You have the right to be represented by a lawyer at all subsequent court proceedings. If you cannot afford one, you can fill out a petition for one, and I will appoint you one. You have the right to a probable cause conference within 14 days. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary examination, and you have the right to that within 7 days of the probable cause conference, the people have to show as to this crime that the crime was committed and that you were the one who probably committed the crime. If they prove that, you will be bound over for further proceedings to the Wayne County Circuit Court. If they fail to prove that, then the case would be dismissed and you would be discharged. Do you understand that?
Yes, sir.
And did you sign, read, and understand and advise? I'm sorry, that's it.
That's
okay.
It.
May 12th
He's on
will be the
autopilot.
preliminary exam. I'm sorry, probable cause conference. May 12th at 9:30. May 19th at 11 will be the preliminary exam. So May 12th at 9:30, May the 19th at 11. So whoever's the officer in charge will have to be here for that. Do you want to address bonds?
Yes, Your Honor.
Go ahead.
Briefly.
That Mr. Wood currently is residing in Rockwood. He has no dependent matters. He's not on probation or parole. He is self-employed as a contractor. He's never failed to appear in court. He wasn't aware of this warrant at the time. But after speaking with Mr. Wood at length this morning, he did assure me he would be appearing all future court dates and understands the importance of doing so.
Trooper, can you tell me when or what his record's like?
He has, I believe, one prior for
drugs.
Yes.
I believe it was dating back to 1990.
Yeah.
Yes, that sounds accurate.
All right. What, do you have anything you want to say regarding bond?
I support the court proceeding.
All right. He lives on Hidden River Drive, correct?
Yes, sir.
They'll do prints over there today, right?
I printed them yesterday, sir.
Oh, you already printed them?
Yes.
Okay. I'll give you a $10,000 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. I'm going to order that you attend AANA at least 2 times per week. That has to be in person. We're going to hand you a form every time you go. You have to have the form signed every time you come to court. You have to bring the form with you. No alcohol, no marijuana, no illegal drugs. AANA twice a week. You have to have the form signed. You have to go in person. You have to test weekly. So you're going to go to meet with probation. They're going to have you test weekly. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You understand everything I have said?
Yes, sir.
All right. So you're going to sit down there, fill out your petition for a court-appointed lawyer. He's going to hand you an AA sheet. Once you're done, you're going down the hall to get your new court dates and, your paper notes. Okay? Any questions? Just make sure you show up. Don't make it worse than it is. Good luck. Mateo Sands. Thank you. Q6B149937. All right. Sir, your name?
Signs.
All right. So you got in an accident. It says you're going to plead to impeding. It says that there was no injuries and both vehicles were driving, right? To the charge of impeding, responsible or not responsible?
Responsible.
Plea is accepted. You got to be careful, son. 195 is your total. I'll dismiss the failure to stop assured clear distance. Okay. Good luck. Slow down. Be careful. Thank you. Aman.
Yes.
Srivastava, Q6W8426165.
Yes, Your Honor.
All right. And hang on 1 second. Where's the other file?
Kim brought it back down. Somehow it ended up down here. I had her bring it down.
All right. Well, no, you don't have to do that. Just make sure you make.
She brought it down. Should be with it.
Okay. So you're Mr. Srivastava. You have to start your video.
Yes, Your Honor. Yes, Your Honor.
Yeah. Okay. Tell me your name again.
My name is Aman Srivastava.
You're going to now plead to impeding traffic, correct?
Correct.
And that's with a commercial vehicle, and then they're going to dismiss the improper lane use. True?
True.
Is that what you want to do?
Yes.
To that charge of impeding traffic, you plead responsible or not responsible?
Responsible, Your Honor.
Do you have that one? Srivastava. I'm going to accept your plea, dismiss the commercial vehicle improper lane use. I'm going to dismiss the no proof of insurance. 235 is your total. Cashier end of the hall to your right. Okay?
Okay.
Thank you.
I think that's the one
Thank
you
you.
put out there.
There's 2 files.
Right here on top. There's no.
Oh, okay. Sorry about that.
Can I
So you
pay
can go on,
this?
listen, you can go online and pay that today, 33court.com, okay?
Okay. Sorry,
You're-
please say one more time.
You're gonna go online at
Yes.
33court.com, 33court.com. And you're gonna use your ticket number from the improper lane use, which has now been reduced to impeding traffic. And you're gonna pay your $235 on that, all right?
All right. Thank you, Ron.
Good luck to you. Slow down, be careful and all that. Good luck.
Let me
Thank
pause
you.
for a
Yeah,
minute.
I will.
Do you guys remember when we went over just some basics about court and how the fines work in the online payment system, and then determined that if someone is charged with a traffic offense and they just pay the fine, it's considered admitting guilt, and then it's done. It's adjudicated. It's finished. It goes on your record. You literally could, if you didn't like somebody very much, if you found out they got a ticket, you could go online and pay the fine for them before they had their court date, and the points would just go on their on their record. They wouldn't be able to argue it down or even protest or deny responsibility. The court doesn't care who pays the ticket, so you don't have to show ID and be like, well, this is my ticket. No, if you pay the fine, it's like guilty, done, and it's quite nefarious. But I think it's something that needs to be addressed in the courts, because that would it's diabolical. You could have some philanthropist out there who's like, you know what, I am going to stick it to the man. I'm paying all these guys court fees, all their fines, all their and doing somebody a favor could in fact cost them a lot of money in insurance, as they get points on the record, may lose their license, all sorts of things. So it's sort of like the guy who went to the drive-through and the car behind them was honking and like, hurry up, and yelling and swearing at him. And when he gets to the window, he says, hey, I'd like to pay for the car behind me too. And they're like, oh, that's awesome. And he pays for it. He's like, and I'd like their food now since I bought it, and I'll just take it with me. It's that sort of petty. But anyway, let's go back to court here a little bit.
Morning.
Good morning.
We're going to take you to the probation lawyer, okay?
The court's thinning out down there in Texas as soon as they get ready to
So
call
he's
the
going to
case,
set
jump
you
down
up. My court officer is. And then you're going to go talk to the lawyer. And then the two of you are going to come in front of me, all right? Any questions? Good luck. Zachary Ryan Dodd, 267-245-888. Your name?
Zachary Dodd.
Mr. Dodd, what's going on with you?
What's up?
Doing very well. Just made a mistake and ended up giving myself a ticket.
Huh? You're going to plead impeding, right? Responsible or not responsible? 150 is your total. Cashier end of the hall to your right, and you're all
I
set.
do have a favor to ask you.
A favor?
I am currently in between jobs. I have to start my.
When do you need to, how much time do you need?
But I have to end of this month.
That's only 2 days.
Oh, sorry, end of May.
Where are you starting in?
CA Hall. I'm going to be built in Bridges for the state of Michigan. Yeah.
Good.
I was kind of let go from a risky union job, and I just paid my mortgage, and it's just been tough this month.
Pay $75 bi-weekly, beginning on May the 18th, okay?
Thank you so much, Brandon.
If you need more time, call the court. We'll go on Zoom. I'll give you an extension. Don't be bashful.
No, I won't.
Just don't ignore me, okay?
All right, thank you.
Good luck. Jackie Lee Hughes. This one goes to Mr. Lee. Jackie Lee Hughes, 268-246-012. Morning, Mr. Hughes. Your name? You're going to plead to impeding traffic, right?
Yes, sir.
Lots of impeding traffic.
You got to be careful out there.
Yeah.
You're close to not being given impeding here. You understand what I'm telling you? Yes?
Yes, Your Honor.
The charge impeding traffic, responsible or not responsible?
Responsible.
Please accept that one is your total. You can go down the hall and take care of that. Good luck. Sir, if you can see my name on the ticket next time, you're not getting impeding from me. Got it? Good. Race Robert Loving.
Judge, I'm sorry, how much was it for that one? I missed your view.
190.
190, thank you.
Race Robert Loving. 26T647698. Defendant failed to appear. Defendant is responsible as charged by default. Case was scheduled for 10. It's 47 rather. Eman Yelazarov, 26F246010. Morning, Mr. Yelazarov. Your name?
Good morning. What's that? I'm in Yelazarov.
All right, so you're going to plead to impeding traffic, correct?
Correct.
To that charge, responsible or not responsible?
Responsible.
All right. Please accept it. 155 is your total. Cashier enter the hall to your right, and you're all set. Good luck.
Thank you so much.
Augusto Contreras Hernandez, 26W841323. Defendant failed to appear. Defendant is responsible as charged by default.
That's another way to get.
Wait a minute.
Just get
Who's the officer on this one? Is Officer Villarreal here?
Officer Villarreal's not here.
Come on up here a second.
Cha-ching.
This was set for an informal hearing.
Yeah, that's what I thought.
Your name?
Hollywood Haven Police Department.
Neither one of them showed, and I just don't feel comfortable. I'm going to have to go ahead and dismiss the ticket.
I do have an iPhone. I'm not finding this name that just zoomed
From
in.
D. August or something like that. You got to identify yourself. What's your name?
Me?
Yeah.
Augusto Contreras Hernandez.
There he is.
Okay.
Guess what? Ticket
Plaintiff failed
dismissed.
to appear. I'm dismissing your case. Case dismissed. Defendant PO failed to appear. You're all set. Good luck.
Appreciate it, Your Honor.
Thank you
so much.
Lieutenant. Have a good day.
You too, man.
You just won the lottery.
Take care.
Go buy a
Bye
ticket.
now.
Bye.
Is Bill Lampaw ever showed up again?
No, and I have called him multiple times. It goes straight to his voicemail.
Bill's not here. No Bill.
I can't. Tristan Gage Helms, 26F246008 and 009.
Impeding means like slowing down traffic.
Yeah,
Driving slowly in the fast lane
Your
would be
name?
impeding traffic.
Tristan Gage Helms.
Getting in the way of the regular flow of traffic. Okay, looks like we're
Any offensive possession of a
the
controlled
defendant was just
substance
walked in, I think.
from August.
Maybe it was somebody else. I think it was somebody else.
No, I just had
This is an orange.
26. My mistake. Forgive me. This is 26F246009. I'm sorry. Your name again.
Tristan Gage Helms.
All right. You're going to plead to impeding traffic, correct?
Yes, sir.
To that charge, responsible or not responsible?
Responsible, sir.
I'll accept the plea. 150 is your total. Cashier under the hole to your right, and you're all set. Good luck.
Thank you, Your Honor.
All right. Norma Graziella Rodriguez, 26F246008. Defendant failed to appear. Defendant is responsible as charged by default. And I don't know what to do with AMPA. They worked it out where he was going to plead on file A.
And I just tried him again and got voicemail again.
You know what? This is what I'm gonna do. I'll just make a note here because the charge was impeding traffic. I'll just make a note, parties worked out agreement. Defendant here by Zoom lost contact. He never reconnected. So what I'm going to do is I'm just going to go ahead and I'll just make a note. C stiff. Defendant was to plead to as charged on file B. And the prosecutor was, or the department rep was going to go ahead and dismiss the A file defective equipment. So no harm, no foul. I'll go ahead and take the plea. I'm going to assess fines and costs on the impeding of $155. You're going to have to send him something and tell him that he has to pay this by whatever, May the 14th or something in that area. I don't care what date you pick out.
Just send him
and I'll
something
still go ahead
like
and
flowers.
dismiss.
And it gets dismissed.
I'll say C stip, CB file. That was the impeding traffic file. And I'll go ahead and still dismiss the defective equipment.
Judges hand out dismissals. Today's your day to show up in court. You might do well.
So that's what I'll do. So he's still going to end up with the same bargain that he worked out with the department rep. Is Mr. Green with that guy?
Who's that?
The probation file I gave you?
Grayson?
I don't know. Was it? Do you have anything else down there? All right, court's in recess.
Court's in recess. Recess time.
Right, but that'll be up to.
This is live
That'll
with
be up
Judge
to a
Raquel
jury.
West.
That's what juries are for. You can go back with the bailiff.
That seems to me.
Let's see what she's working on before the case gets called here with the jury selection.
Mr. Kitchens is on his way over on the wheel.
Perfect. Thank you. She was like, oh, that was funny.
Should we back up and see what was funny while we wait?
Mr. Parker. Ms. Holmes and Mr. Parker are both in the back. That's fine. If they're working on something. Dang. That Ms. Holmes. And then we'll
Okay, we're going to back up and see what was funny. Just back
for
up.
the record. Thank you.
Let's back up to right here when she stands up. There we go.
No contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
Yes.
State tenders number 1.
No, Judge.
It's admitted. All right, Ms. Bailey, I'm going to find that you entered your plea of guilty freely and voluntarily.
Went back too
Find
far.
again that you're mentally competent and you understand. Oh, she's
Oh, that's fine.
okay.
She's transported. Yes, ma'am.
Okay. We'll reset that. You have a Relacia Mouton.
Here it is.
Those are rejections, Judge.
Relacia Mouton.
Watch this guy with the binder dance up to the podium. Here he goes. And thump. Not sure what he did
Good
that
morning
for.
again.
Good morning.
There's 5 cases. I can do. Are both of those
There's 2 states.
possession of controlled substance state jails and all the rest are second degrees? I can do it without filling that. Good morning, ma'am. Are you Relacia Mouton?
Yes, ma'am. It's morning.
And Ms. Mouton, in cost number 25 DCCR 0907.
It's a beautiful state. I absolutely love it here. I'm glad you enjoyed it.
Before we go forward, I'm going to take judicial notice of the court's file. It looks like there was an evaluation done by Dr. Capon last year with regard to competency, and that we received that report back in October, and Ms. Mouton was found competent to stand trial. Is there
did this in January 20th.
The competency report's from October.
You found her competent January 20th. That's what my file reflects also, Judge.
Okay. Maybe we didn't get her back. I don't know why.
She didn't.
There's a lot of things there.
Hold on.
I don't think she was ever taken anywhere.
No. So I don't know why. Anyway. Found competent based on that report. There hasn't been any other reports that I know other than the Dr. Crapon report from back in October. And so any other issues at this point with regard to competency?
No, Your Honor.
All right. So in cause number 25, DCCR 0907, Ms. Mouton, you're charged with a second-degree felony offense of assault on a peace officer. And what that means is that if you go to trial and you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand? I need you to answer out loud for the record. Thank you. And then in cause number 25, DCCR 1466, you're also charged with assault on a peace officer. This one is from August 17th of 2024. The first one that I read out was actually from May 5th of 2025. So the second one, same thing, is a second-degree felony. If you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1467, you're charged with the state jail felony offense of possession of a controlled substance from August 17th of 2024. And in that case, that means that if you went to trial and you were found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand that?
Yes, ma'am.
And then in cause number 25, DCCR 1468, you're charged with assault on a peace officer, and this is from that same date of August 17th of 2024. Again, if you're found guilty by a jury, the same punishment range applies, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then the last case is 26 DCCR 0120. You're charged with possession of a controlled substance, a state jail felony from August 8th of 2024. And in that case, if you were found guilty, the range of punishments between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
I have here on the tablet plea bargain rejections that you've signed with Mr. Rojas that shows that the district attorney's office has made offers in your cases if you wanted to enter pleas of guilty for 8-year term in prison and on all of those assault on a peace officer cases that would run at the same time concurrently. And then a 2-year sentence in the state jail prison on those two.
The offer was actually we would dismiss the state jails, Judge.
Okay, so there would be a dismissal in the 2 state jails with, I'm going to make that notation.
Because I just signed paperwork refusing 2 years for both of those.
You did. So obviously the bigger cases are the 8-year terms. So what the offer is, and so that we're all on the same page, it would be 8 years TDC on the 3 assault on a peace officer cases with dismissals in the 2 state jail cases. Does that change your mind?
No, ma'am.
Okay. So you have every right to reject.
Probation.
Hang on. So you have every right to reject those offers. I just need to make sure that you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty, and you understand all of that.
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get them set for trial. Ms. Mouton, listen. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am. I thought you was trying to make me keep him.
Well, it wouldn't be the worst thing because he's one of the best lawyers we have.
I understand.
So, Mr. Rojas, you're released. And Ms. Mouton will give you a new attorney. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff.
All right. It wasn't very funny, but
hold on, come back. Mr. Smith, do you anticipate there would be any reason for that offer to change?
No, Judge, I thought that was a very generous offer.
So I do want to make sure you understand that just getting a new lawyer doesn't mean things are going to change. The offer is what it is, and so there's not going to be any change just because there's a new lawyer.
I've seen the tapes, and it's not enough on the tape to show that I deserve 8 years.
All right, but that'll be up to
trouble in 20 years.
That'll be up to a jury. That's what juries are for. You can go back with the bailiff.
Makes sense to me.
all right. Wasn't very funny, but let's jump to current time. Looks like we're on break right now, waiting for the right players to show up in court. The judge did deny Karen Reed's request to postpone her sentencing. That means it's going to go forward on Eric's birthday. That'll be interesting. That's here this next month, I believe. Did I say Karen Reed? Did I say Corey? I thought Corey Richens. I even said Eric Wright. I got the Eric Wright, who was the victim. She's been renamed. We can't have any more KR trials. Can we just agree on that? Anyone who's named KR, we're going to dismiss the charges from now on. If you're a KR name, you're in luck. No pros on everything. I cannot keep them straight. All right, docket's moving very slowly. Might not start till this afternoon. Karen's the OG. Corey Reed Richens. You said Sarah Boone. No, I know I didn't say Sarah Boone. Yes, no more KR, please. Kim, you're in luck. No prosecution for whatever it is. Caleb, oh my goodness, Caleb Flynn, spelled with a C and an F. It's different. Kelly in Tennessee, member for 33 months. OG. 3 more months to get a new courthouse. Got a jury summons for week of May 11th. Kelly, that's exciting. I would say keep us in the loop, but obviously you can't. When it's all over, if you want to talk about it, we'd love to hear. Rebecca, I'm super cautious about playing music because music has an aspect of AI in it, in its creation. And I mean, every single day I'm getting a flood of reports of channels that are shut down for what's called inauthentic content. And even if there's just a tiny portion of AI in it, people are getting struck down. I mean, big channels, 500,000 subscriber channels that have been around since 2015 are getting zoinked. Crazy stuff. So I'm just being a little cautious there. Kiki's Garden member for 34 months, many ups and downs, but nothing but support with his amazing community. Now working on in my dream job, the courts. Thanks to URA for bringing us together. Kiki's Garden, you are most welcome. I'm super excited about that. Hope you absolutely love it, and they pay you much more than you're worth, which is a lot. We're erring on the side of caution, or erring, depending on how you read that word. Yeah. I don't want to gripe about it because obviously YouTube has been a huge blessing in my life, but let's put it this way, I'm not sleeping at night. I'm worried about this. It is so, it's out of my control, and I just have to, I'm worried about this case we're following right now. There might be a video played that may show the defendant in possession with a dangerous item. And that's all it took to get some channels timed out with a terms of service violation. So, crazy. I'm halfway on my soapbox. Halfway. All right, let's see. Still waiting for a little audio from court just to see. Oh, that is a nice tie. It's almost like a Chargers tie, right? Is that the what teams use that? Is it the Chargers? Let's create our own crime tube. You know, it's a funny idea, but here's the problem. It's the Giants. Okay. Buffalo Bills, Houston. Everybody uses the red and blue. It's a funny idea, but I was looking this morning at some creators in this area of YouTube that are going to another platform because of the problems here. So we need a safe word for where to go if we get stuck. Facebook, yeah, that would be great. Make sure you're connected to the channel on at least 2 different social media platforms. Thank you. Kelsey, Sleeping Pill Fund. Kelsey, thank you very much for your amazing, generous donation. Oh, man. Thank you. Thank you very much. Appreciate that. Mostly moved to Kick. I haven't looked at Kick yet. Obviously, we spent a little bit of time with Rumble back when we had a little issue way back years ago, and it wasn't good. Like it wasn't great, is what I'll say. Rumble was not great then, but I haven't been back since to see if they've improved some of the issues. We had a lot of laggy processing, delay, had to restart. It wasn't smooth, and that's something that YouTube's relatively good at. So, Kathy at GRI got a hold of YouTube really quick and got help. Have you asked her? She had a different issue, Birdie. She had somebody hacked her account, like her Google email that controls her YouTube account was hacked, and they handle that very differently. Let's see. Rumble has matured. I might check it out. We're currently set up right now. Look on Discord. I will check out Discord. We're currently set up right now that we could stream to 3 different locations simultaneously, and that's on my end using hardware, not like Restream or StreamYard or something else that introduces a bunch more issues. I could directly control 3 different locations, and that's pretty good. Let's see. Eunice, I see an article in a language I don't understand. Is it? It's Dutch to me. I'm not. Oh, his tie looks like the Danish resistance. Oh, okay, got it. I saw on the bottom. I was reading the top. Got it now. The prosecutor or the attorney's tie was matched the Danish resistance armband colors. All right. You got to become a Twitch streamer in speedrun trials. You can always use your radio license. Ironically, that's one of the few things that my ham radio license is not allowed to be used for. I can't do anything that would involve earning money at all using ham radio. You can't even provide emergency services for somebody who really needs it and let them give you a tip afterwards. It's not allowed. The way I thought you said Runkle at first was also confused. I thought you loved Runkle. Also, wait, did you see him? I do love Runkle. Ian's amazing. What are we talking about? I don't think I mentioned him this morning. We're talking about Rumble. Okay. I'm sorry. I love Ian Runkle. I'm talking about Rumble, the platform, similar to other social media video sharing platforms. Kilo Bravo 5, Romeo India Papa. Welcome. I don't give out my call sign because it links directly to my address, but I'm also a technician, no code, with the Kilo Delta as a start and the 7. So, all right. Yeah, we just have to play safe. We'll figure it out. We'll work it out. I've got plans. One of the things we're doing, we've changed our designation as a channel from entertainment to news, which changes how the algorithm puts things out. We're more news and events now, and I guess technically politics in the eyes of YouTube.
All right, Mr. Parker, are you ready on Jabbar Bell?
I was going to have about 4 injections.
Good.
Meaning, already got updated to the young guy or ever.
One of the video. What?
What's he say about?
Is it Audrey Horick? Did I say that right? I just saw I've changed color in my tiny courthouse. Woohoo! So glad to be part of the RA fam. Thank you very much. Welcome, welcome, welcome. 6 months.
It's French.
Time flies when you're having fun.
Can't tell. With my complete name.
Seeing if the judge can just wrap up this stuff and get started with the jury.
Good morning, sir. You Jabbar Alexander Bell.
Good, man.
And Mr. Parker, will your client waive the formal reading of the indictment in each of the cases?
Excuse me while I get my final piece.
Okay, we're going on. Let's see. Let me.
It's possible. It's possible it does.
Would
yes. I'll update your letter of recommendation accordingly as well, Greeners.
We're going on all of the counts. It looks like.
Yes.
How many counts are there?
Do a third. It's gonna take me a second. I'll figure it out. Mr. Bell, in cause number 26, DCCR 0139, you're charged with the state jail felony offense of theft of property with previous convictions from September 25th of 2025. The indictment alleges you were previously convicted of theft May 18th of 2018 in 2 cases, and then after that was final December 3rd of 2021. And then the indictment further alleges that you were previously convicted of the state jail felony offense of unauthorized use of a vehicle June 24th of 2019. And after that was final, you were convicted of evading arrest or detention with previous convictions of state jail felony November 8th of 2021.
He's a runner.
And after that was final, you were convicted of burglary of a building, a state jail felony, June 26th of 2023. And how do you plead to that charge?
Yes.
And are those all of those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
And I think
Those priors are not going to look
Then
good
we
when it comes to
have-
sentencing.
Clause number 26, DCCR 0140. And, sorry, just a minute. And in that case, you're also charged with the state jail felony offense of theft of property with previous convictions. And that one is from December 16th of 2025. The indictment alleges the same prior theft offenses, the 2 from May 18th of 2018, and then the last one from December 3rd of 2021. And then it also alleges those same prior 3 state jail felony convictions. And how do you plead in that case?
Guilty.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are those prior convictions all true?
Yes, ma'am.
You done did all those things. Fanny Pack member for 21 months. OG. Thank you. Thank you. Thank you. Let's see. Did I miss anyone? Kelly in Tennessee, 33 months. That's awesome. Larley Annie, member for 18 months. Happy Tuesday to you. Regina Adams gifted a membership this morning. And Watson, member for 17 months, says drums. Welcome to the gallery, by the way, and Watson. Ricky C., we are in fact an OG as well.
Finally, we have 26 DCCR 0274. And you are charged in that case with evading arrest or detention with previous convictions from January 21st of 2026. It alleges that you were previously convicted of evading arrest or detention March 13th of 2017 and also November 8th of 2021. So this one does not list those other priors. So it just is a state jail.
Yeah, it's supposed to.
And I apologize. I didn't notice that it didn't list the other priors.
We don't object to an amendment if they,
Now, the state would ask to amend.
I'm not writing all that in.
okay. You want to dismiss that one?
I mean,
That is the,
evading arrest or detention with previous convictions.
gosh, I hate dismissing and evading.
I mean, I can reset it. Y'all can file an amendment.
It's like they got away
or
twice. Huh?
if you want to write it out, but that's too much for just an amendment. That's 3 prior offenses. So whatever y'all want to do. Y'all want to talk about it for a minute?
I can write them out if I need to be consistent.
Why don't you do either handwritten or typewritten if you want to get down here real quick, a notice of to enhance with those 3 in it. And then I can read the the notice to enhance.
Okay, I'll do that very quickly.
I'll hold it.
Thank you. We're ready.
Evangeline Light, member for 36
All right, Jameldrin
months.
Woolridge, Mr. Lewis,
3
Ms.
years.
Malfino.
My one and only place for hanging out with wonderful folks. The best coverage and crazy stories with their phenomenal boss, R.A. Evangeline Light, thank you very much. OG! Congratulations on your red courthouse. Okay, this is your neck of the woods.
Uh-oh.
Oh, now she went off the record for this part. Just trying to keep an eye on the courtroom to see if our defendant gets brought in. That would be our indicator that we might be starting soon.
Allen's.
That's not him.
One. All right, are you Jameldrin Woolridge? And so before we go forward, Mr. Lewis and Ms. Malfino approached about possible solutions to the issues that we have here with Mr. Woolridge is on probation. In 3 cases, there was a new offense that occurred while he was on probation, but before he went to ISF as a part of that probation. And what I want to know before I consider any type of continuation of probation is couple, I guess, number one, how do you have any idea how he did, Mr. Kitchen? I guess, and before you go forward, would you raise your right hand? You swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
I do.
Any issues with regard to behavior at ISF that you were aware of?
None that I'm aware of.
Okay. When did he get back from ISF?
I'm not sure exactly. I did not receive Mr. Woolridge under my supervision until September 26th of last year.
Okay. And so, how has he done from then until he was incarcerated on this?
And he was very cordial with me. We've had cordial bit surprised by this.
I thought this guy's sideburns.
Stuff that's been going on with it.
Okay. Any
or the end of
positive
his
drug screens? Any issues at all since you had him in September?
No.
Okay.
May I just ask him one question for the court?
Of course, please.
Mr. Kitchens, you brought to my attention, and I think the clerk has also sent it to Mr. Lewis and myself. His behavior in jail is less than to be desired, correct?
Yes, that's correct.
And would you characterize that as his association with those individuals who the court is very well aware are in jail, that is a different side of him than you saw while he was out on probation under the guidance and eye of the court and his family?
That's correct.
He's hanging out with people of ill repute in
with the understanding, I'm sorry, Judge, if I may, that obviously Mr. Wildridge is facing quite a bit of time from this court on a revocation. And would it be your intention, along with the court and myself, to make it clear to him that if he is given this opportunity, that if he comes back before this court, that he's not looking at maybe what he would be looking at today, but probably 3 times in advance of that amount of time?
Yes.
And do you think he is capable of and understands the seriousness of what it is he's facing?
I believe he does, yes.
From your interaction with him.
Okay.
Thank you for the 5 gifted memberships.
Mr. Woolridge, this is tough for me. Because you've been given a couple of opportunities and this would be another opportunity. And I don't know, I don't want you back in here. I don't want you to violate. I want you to be successful. You've been on a decent path. But what you did and thought you got away with, things catch up with you, right? And so that one's a 2 to 20 case. I could revoke you on your ag robbery and send you to prison for the rest of your life today. The rest of your life. And based on the history and what's been going on, some big fat number is probably what you deserve. And so I don't know how to be any more clear than if I give you this opportunity with what your attorney is working out with the district attorney, that Mr. Kitchen sounds like he's willing to work with you. And if I go along with this and leave you on probation and put you on a new probation, if you're back in front of me, there will be absolutely no argument about continuing probation or some low end of the punishment range. That won't be what's happening. Do you understand? Mm-hmm. You're going to be on 0 tolerance. That means no mistakes on probation. You've been on it long enough now to know how to be successful or not on probation. And if you just live your life right and do what you're supposed to, that shouldn't be a problem. It's only hard if you're doing the wrong things. Does that make sense? Yes. All right, y'all can do the paperwork.
Thank you, Judge.
Thank you.
Wow. Facing possible life in prison for his bond violation. Parole violation.
Mr. Parker, you have Lloyd Calhoun.
Yeah. That's a choice.
Judge Parker didn't have this thing yesterday. I said, you better do that because she won't let you plead. What is that? I think they just said, you have to have the attachment.
All kinds of new stuff's happened since he was up here, all the words that I have to say. Good morning. Are you Lloyd Calhoun? And Mr. Parker, will your client waive the formal reading of the indictment?
He will, Judge.
And we're just going in the possession case, is that correct?
That's correct, Judge, but on the, with the prior enhancement counts.
His collar looks a little tight.
Third degree, and just so to be candid with the court, in 2019, he also received a 5-year sentence. This same 5-year offer was made based on the underlying facts of this offense. What he did was pour some PCP out on the floorboard carpet of the car, which made it difficult to measure the quantification.
Okay.
Can't
All right,
measure
Mr.
PCP on
Calhoun,
the
in
carpet.
cause number 25, DCCR 1266, you're charged with the state jail felony offense of possession of a controlled substance from April 14th of 2025. And how do you plead to that charge?
Yes.
And are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Listen.
That indictment further alleges that you were previously convicted of unauthorized use of a motor vehicle, a third-degree felony, May 17th of 1993. After that was final, you were convicted of possession of a controlled substance, a third-degree felony, June 3rd of 2002. And then after that, you were convicted of unlawful possession of a firearm by a felon, July 8th of 2019. And are all 3 of those prior convictions true?
Mm-hmm.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? He went over those with you?
Yes.
Do you fully understand those documents?
Some of them.
What do you not understand?
I gotta look at it to see it again, but most of them I do.
Well, let me go over a little bit more with you. Do you understand that if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow this agreement, you can't change your mind later, right? And it looks like the agreement's for 5 years in prison with a dismissal in cause number 25 DCCR 1267, which is that tampering case.
Yes.
Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Calhoun is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Back time?
Yes.
No.
Just the time that we've had a hold on you here. So I don't know if you are serving time anywhere else or were anywhere else. Okay, so you'll get that credit. I'm going to, is it not printing? Okay. I'm going to hand you in just a minute, a trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You're also going to be handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. You already know this because I know you have a history with a charge of this, but I'm required to read this to you. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. And then I will sign a dismissal as soon as it comes through in clause number 25, DCCR 1267. So name it now.
You put in the holes.
Well, I think I probably printed it twice at least.
And this is, what I printed stuff for Pam a while ago,
Oh.
and what I gave her wasn't all of it. Apparently we ran out of paper, but I didn't know.
I printed some stuff also from that other case.
Okay.
I printed one for me, several things for myself.
Well, I think it's something.
Okay, all right. Here you go. You can go back with the bailiff.
No. Yeah. I mean, ask them every time. You understand. I tell you everything you're gonna say. Give me questions. You understand everything I've gone over to you.
I know.
They gotta say something. I guess he understood, he didn't understood.
That's true.
Pam.
Oh, she probably wants to file that.
Well, help that copy I gave her.
Mr. Parker, you've got Patrick Trahan, 2 cases.
Patrick Trahan.
Right here.
There's actually 3 cases, one of them being dismissed.
Judge, that was based on the fact that we just came back confident we're trying to dispose of that situation, that window.
So, which one's being dismissed?
The 9-6, whatever, then 1-6.
1916. Okay. Good morning. Are you Patrick Trahan?
Yeah.
And Mr. Trahan, I'm going to take judicial notice of the court's file in all of his cases. Mr. Trahan was evaluated for competency by Dr. Gapon. And we received that report dated March 2nd of 2026. The finding in that report is that Mr. Trahan is currently competent to stand trial. Any other evidence with regard to competency
No, you're right.
from the state?
No.
Then at this time, I am going to find that Mr. Trahan is competent to stand trial. Mr. Parker, will your client waive the formal reading of the indictment in each of the cases?
No, you're right.
And are we going on count 1 only? I'm the assault on a peace officer.
Yes, sir. We may need to go on both on the stage.
Okay, hold on a second. Sorry. All right, Mr. Trahan, in cause number 25, DCCR 1917, the state's elected to proceed on count one only. It alleges you committed the second-degree felony offense of assault on a peace officer, and that's from November 18th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And then takes a minute for me to get it. And cause number 26, DCCR 0592. You're charged with the state jail felony offense of possession of a controlled substance from March 17th of 2025. And how do you plead to that charge?
Yeah.
Again, are you pleading guilty freely and voluntarily?
No.
And because you did what they charged you with? Also, in that indictment, it alleges that you were previously convicted of the state jail felony offense of theft of copper, bronze, or aluminum, August 11th of 2014.
Copper, bronze, or
And
aluminum?
then after that
I'm
was
guessing
final,
copper.
you were convicted of burglary of a building, a state jail felony, May 15th of 2015. And are those two prior convictions true?
Yes.
In each of your cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, I do.
Do you fully
Ricky,
understand them?
thank you, thank you.
And do you
Hello?
understand if I follow
Hello?
the agreement that you made with the district
Sorry, I'm
attorney
having my son help
that
me
you'll
with the
be
internet.
waiving or giving
Just one
up any right to appeal? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
Objection.
It's admitted in each case. Get caught up here.
I may have
Right, so
fixed
I'm going
my
to find
issue.
that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you entered your pleas of true also in the second case freely and voluntarily. Find again that you're mentally competent, that you understand the nature and the consequences of your pleas. And cause number 25, DCCR 1917, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 26, DCCR 0592, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Find those 2 prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Those 2 cases will run concurrently, which means together at the same time. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a trial court admonishment, or the written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, and I will sign that dismissal now in cause number 25, DCCR 1916. All right, you can go back with the bailiff. All right, let's see, Eric Tran.
More for actually. I don't have any case. I just took comments without taking player message. I played with everybody but you and Donovan. And then one of the comments got reset and one was in comment.
So you guys say P, but I don't know, you gave me credit for time served on the reckless.
Yeah.
Are you gonna dismiss it or is he gonna end up pleading?
Oh.
It's training.
These are also.
Yeah, right. Okay.
I'll get them to do that. Is it set today? Do you know?
I don't know. They usually set it today, but
I'm asking.
yeah.
Asking where it is, and I'll go to that.
Is it here? We got two.
It's in here.
Yeah, it's here. And y'all see my guy, you know, misdemeanor. What do you want? What's your misdemeanor? Is it 2? You do. I mean.
Good morning, sir. Are you Eric Tran? And Mr. Parker, will your client waive the formal reading of the motion?
Okay, hold
Mr.
please.
Tran, and cause.
Hold please. I just wanted to say, I finally figured out something really cool. I figured out how to incorporate my cell phone, like this phone right here, as a camera on my computer. So it's flashing around because I've got a weak cell signal, and it's sending it 4K and converting it. But I can do this from anywhere in the world. I can connect a cell phone and it works. It's working. So what this means is that, let me turn off the judge here because she's being loud. Mute. What this means is that I can send anyone who's a little bit techie, a tiny bit techie, and has a cell phone, I can send them an XML file, which they can load using a couple buttons on a free app, and they could connect with their camera directly to my system. So this is super exciting for me because it's using this box right up there on top. My camera's so dirty, that's embarrassing. Let me clean it a little bit with my shirt because that's how we clean cameras around here. There we go. Now it's not quite so. It's using this box up here on top, the little tiny one right up here. That one. To take a stream over the internet because this is going over my cell phone signal. And it works. It works. I'm stoked. I'm super, super excited about that. So, mostly, if it's an iPhone, they come pre-smudged. Okay, mostly, so it's not hacking, but apparently the manufacturer told me that no one had set up the system that they know of had ever set up their system to work the way we just got it to work. Why is your phone blinking? Because I live in a Faraday cage, and my internet signal to the cell phone signal is poor. But if I were outside, this would work great. Also, I'm sending a 4K 60 frame per second image like that. So, and then I can also send what's called talkback. So I can talk to the cameraman or the person holding the cell phone, and they could hear it in their earbuds without it actually going out over the air. So like, oh, you're on in 5, 4, 3, 2, go. You know, it's really cool. So that makes you the OG. I can have reporters. Yes, very much so. I need to do a little bit of work because it requires some static IP issues, and those who know the technical side of that knows that I can't just give this information out. It has to be a trusted source. I need to lock down the firewall. Your camera's dirty because you answer mod chat and your skivvies. What? Now we are a news streamer. Yes. All right, just waiting for our Judge Raquel West to finish up her docket so we can get back to the trial that we had before.
You have Edwinia Johnson.
And
Yes, John.
She might be a little bit because the jury's not there yet. I don't think they finished selecting the jury. So we might do a bit of court hopping still. Linda Lou says, it means you are truly the GOAT, RA, the very best place to watch court. Thanks for everything you do. I love it because I can control, basically, I can send a camera somewhere, like I can send a reporter somewhere, and I can control it from in here and still have full access to the stream and, take the audio and make adjustments even to their camera from my end. It's really cool. Full Remy, remote production. Imagine if Selena had that during the Corey Reed. Yeah. Obviously, we can't use it in court unless they allow people to film with their phones. Very few courts do. We're not trying to do it that way, but that made my week just to have this work. I can't wait to call in and report live from this week's Fight Club. Yeah, no, thank you. It would be great for storm chasers. It's fantastic. Let me get a tiny bit more nerdy, okay? This uses SRT. That means when I go live with a feed, which it's less than a second delay. Let's see. You know what? The glitch is because I've got different. I'm monitoring this on my receiver directly, decoder directly, and there are no glitches. The flashing is because I've got a frame rate mismatch. That's it. Anyway, what was I saying? Maybe I should join before there's a price hike. No, this technology. I've been talking with manufacturers about paying for someone else to provide equipment that can do this, and it's in the $20,000 up front cost with another $600 a month plus per minute charge. And so being able to do this on my own I've got a fixed cost that I've already paid for, and it doesn't cost any more to incorporate that. That is awesome. Oh yes, it uses SRT. It uses SRT because the compression is H.265 instead of H.264. Basically, it means it can take a video signal and turn it into numbers and, just numbers, ones and zeros, and send it across the internet, and it sends it in a much smaller package. It's more compressed, but it still has broadcast quality. And so I don't need to have a huge, wide, massive broadband internet connection to send this. A very simple connection, even a spotty connection, can work, which is just, I'm over the moon. I'm excited. Yay, RA is going to storm chase while streaming court. The framework is a matrix glitch. I'll have a good aha moment. I'm stoked. I wish I could show you here. Let's do this. Let's put over there. We'll put 8, and over here we'll put 4. Okay, so I'm gonna turn on my phone, and you guys can see exactly how fast it connects to. So I'm going to click the button, and when I click the button, I'll do 3, 2, 1, and click it, and watch the screen behind there. 3, 2, 1. I turn it on, and we have that's the delay. That's the entire delay, which is just, oh my goodness, that's awesome. That's awesome. So, no huge delay like satellite or anything else. RA is going back to pay by minute days. Ugh. All right, where were we? We're watching court. And we're waiting for the judge to finish up her morning docket, which has taken her sweet time to do it. YouTube required live stream from Mars Home or Depot upcoming. Speedy across the country. Yes. We're talking. I'm there will be a longer delay. There just is. A signal takes time to travel. Even the speed of light takes a little bit of time, right? And we're not doing fiber direct all the way across the country, but that is just awesome. All right. So maybe I'll reach out to one or two of you that they're a bit comfortable with playing with some settings in a camera app, because the app is Blackmagic Design camera app. It's free, but it's not just like opening up the camera on your phone and pushing the button to take a picture. It actually has a menu. You have to go in and say, I'd like to live stream using a decoder, and then you have to upload an XML file, which you have to save on your phone, which I'd have to send you, and things like that. Because it's sort of like the passwords and the information to get through the internet to reach this machine. So we'll work on that. That's the next thing. All right. I should probably try and downgrade it and see if it's. Let me go back to watching court, and I'm going to do a quick test again.
The whole truth and nothing but the truth.
Yes, ma'am.
Thank you. And so, were you able to have any meetings with the defendant, Ms. Johnson?
Yes, ma'am. I met with her in October when she first got placed on probation, and then again in November. But when the offense occurred, she then reported to me when I met with her in November. And that kind of was alarming to me. And then also in November, she told me that she was in Houston. No, I'm sorry, I think that was December. She went to Houston without letting me know first. So that was also another concern. And so there may be some compliance issues with that.
Okay. Ms. Holmes?
Well, Your Honor, based being that she's on deferred, we would ask that a reasonable bond be set. I do understand the concerns of the department and the state, being that she wasn't on probation very long at all before the new alleged offense occurred. And with speaking with Ms. Johnson, she is realizing the severity of the cases that she is on probation for, and she has expressed to me that she wants to get this right and get back on track with babies.
For the record, I'm reviewing at this time the probable cause in that underlying offense. Give me just a second, please.
We are reviewing. What is the best backup for Wi-Fi if you lose regular service? Probably a cellular hotspot if you have a phone that can share the internet. That's going to be probably the cheapest because you may already have it on your plan, but you don't want to use a lot of internet that way because a lot of them are limited. Next best would probably be...
Who's taking care of your kids, Ms. Johnson?
My brothers and my sister, and the boys are with their father people. There's
Okay. Obviously, it gives me a whole lot of concern that she was on probation for a week. Obviously, they're allegations, but they are serious, and it shows a lack of concern for being on 3 felony probations. So I am going to set bonds, but in cause number 24 DCCR 2151, I'm going to set that bond at $50,000. And then I'll go over conditions in just a minute. Cause number 24 DCCR 2152, and 2153, set each of those at $25,000. Order as a condition of bond if it is made that there will be a GPS monitoring device and Ms. Johnson would be on house arrest. So I would have to know an address, who is living there, and she would be required to remain at that address other than visiting an attorney or coming to court. And be required to pay the cost of that GPS monitoring device, keep it on at all times, keep it charged at all times. Obviously have absolutely no contact or communication with Isis Martin, who I believe she's out, right? She was here yesterday. Smart, that sounds familiar. Anyway, and then also no contact with Harmony Boatner, and not to be at 901 Main, anywhere near that address in any of the apartments. Is that where anybody that you plan on living with lives? Okay, so you're not supposed to be, you won't be able to be obviously anywhere around there because you'll be on house arrest. But specifically, you cannot have any contact or communication with the co-defendant, with the complaining witness, or anybody that has anything to do with this. That means in person, but it also means sending messages or sending messages through other people or anything like that. Do you understand?
Yes, sir.
All right, we'll get it set for an announcement on the motions in the case then.
Yes.
All right, you can go back with the bailiff. Yeah, I guess probably, but it's not gonna.
Thanks for taking a reasonable recent Thursday here. Appreciate it. I didn't say you weren't. You're always reading now. Just sometimes a little more reading. You can always do it.
What's the bond set on the robbery?
Yeah, I have no idea. Oh, she is? Oh,
22,000. No contact.
Oh, so she must have posted that bond before the MTRP.
So this is one of those issues that I'm having, I think, where they're not able to see out there sometimes if somebody's already on probation. And so some of those bonds don't reflect that they're already on 3 probations, because I don't think any of them would have done that. Mr. Smith. Just so you know what we're discussing, and a concern that I have in this case, sorry, Ms. Holmes, is that Ms. Johnson's bond on that underlying robbery is set at $22,000. She's technically already on bond on that case. I don't know that that might be something where we've had some issues with the ability for the magistrates to see if somebody if they're on probation, because there's not MTRP files yet when those, and so they can't really see that. We're working on that in the system. Maybe something that you would want to take a look at and potentially ask me for some thing.
Yes, ma'am.
Okay.
Take care of that. There you go.
So it's like 50 and 25 and 25, right?
50 and 20, 25.
220.
Ignore me, don't care. Welcome. Thank you so much for joining. It's not a little thing. I appreciate that very much. Your support is, it means a ton. Thank you. Thank you. Thanks for being a member. Congratulations on the Yellow Courthouse as well. You freed up for room for another person in gray. That's awesome. Okay, we are still waiting for the judge to finish her docket work. We like her. We're sort of just getting a feel for how her morning goes, because that might play into how she reacts to how the afternoon goes, which was fun watching the jury selection yesterday. That was probably one of the more entertaining jury selections we've watched. Prosecutor over there in the what are those? Are those Keds? What's he wearing? Converse? Looks like he had a rough night. A little bit tired. She has been all business today, save for something that amused her briefly. Yeah, and it wasn't very amusing. We went back and looked, and it wasn't very funny for us. Let's see. Wait for it. I think that's our defense attorney in the corner over there. Just we only see his elbow. So I think he's here. Let's see if he walks on the screen here just briefly. Wander around, sir.
Barnesworth is saying the same thing. He's on a pond out. So I think I didn't know. Yeah.
Devin Murray, Miss Holmes.
He didn't stop. Oh, Ashley wants that live on. No, we got a plea. We got a plea.
They're playing.
It's a plea.
That's okay. Thank you, ma'am.
Because I filed it yesterday.
I'm so proud of myself too. I had already kind of the 46 ran that.
Look at you.
We need to for each other. Every day I'm like, I could backslide, but then I go elsewhere. Before I get my bills. Judge, on this case with the court's permission, we're going to proceed on the lesser included. He has agreed to some stipulations that I would rather not put on the record. It's court can read between the lines on that.
Sure.
And also the co-defendant, for your information, was in custody in Orange County on a motion to revoke, I believe, a misdemeanor one. I've spoken with the prosecutor over there. It's my thought that probably Ms. Holmes let me know Louisiana has since picked him up, that they probably led him to credited time on that MTRP, and Louisiana grabbed him before we could grab him back. And that may ultimately dispose of the entirety of this case.
Dang it, Louisiana. You went and ruined things, huh? Good right.
All right, sir, you're
Stick your
Devin
finger
Murray.
in the pie
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Murray, in cause number 26 DCCR 0346, the state's elected to proceed on the lesser included offense of robbery from January 15th of 2026. And how do you plead to that charge?
Might go 2 days.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? You fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 4-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, have no contact at all, communication with the co-defendant, and that's Lugo?
Jesus Lugo.
Jesus Lugo. You understand?
No.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Murray's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty to the lesser offense of robbery freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you in the case, and then we'll come back later for sentencing. So based on all of that, Ms. Malfino, what's the state's position with regard to a reduced bond?
The state is in agreement with that, Your Honor. He does not have any criminal history to speak of other than a possession of tobacco lab. All the criminal history is really associated with his co-worker, Mr. Woodford.
All right, so he's pleading.
No, I know.
Okay. So, what I'm going to do, Mr. Murray, based on the nature of your plea agreement, is reduce your bond in your case to $1,500. If you make that bond, it is important that you understand a condition of that bond is to have absolutely no contact or communication with Jesus Lugo. And to do everything you're supposed to, go straight to the probation department. If you get released, get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement. If you get arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. So it's very important if you make that bond that you get out, you do exactly what you're supposed to, go straight to probation, and then we'll see you back here at sentencing. All right? You can go back with the bailiff.
Wow, that's crazy, AZ.
We started. And then the.
All right, Mr. Lewis on Jameldrin Willridge. Oh, you just did paperwork on the new case? Okay. So is it the state's intention to dismiss the MTRPs?
With court's permission.
Yeah.
Whatever you prefer.
That's fine. No, I don't care which way we do it. If you want to dismiss them, that's fine, or we can go through them and I continue, but either way, it's kind of the same.
Okay.
All right, again, you are Jameldrin Willridge, correct? Speak up for me. And will your client waive the formal reading of the indictment?
He does, Judge.
Didn't we see him just a minute ago? What are they doing?
Find it now.
He was just here, like 10 minutes ago.
Mr. Willridge, in clause number 25, DCCR 1804, you're charged with the second-degree felony offense of burglary of a habitation from August 29th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow this agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And the agreement shows that this is for a 10-year deferred probation.
They drew it up.
What about, this is the
10
one with the
years.
shoot. What about restitution? Right, this is the one where he went.
Yes,
It's all the shoot.
It was 100,
It was a lot.
approximately 100 pair of Jordans. You would think I would know how much those cost.
Whoa.
So here's what I might do.
100 pair of
just so that I
shoes?
have everything that I need. Go ahead and get a pre-sentence report.
Okay.
You can get with them, get
Yes,
a
ma'am.
restitution amount. You are going to be required to pay restitution. So if you still have some of the shoes, find them, get them, talk with Mr. Lewis. They can be returned so you don't have to pay for them.
Okay.
He did get it all back?
I'll
Okay.
confirm that, Your
So
Honor.
we're going to just get that confirmed between now and then. And I do want to go ahead and kind of get an update so that the new case is in a PSI, since we don't have it, the new case. I don't need a little update on the probations, for sure, double check on ISF and how that went, but it sounds like there's not an issue, but I just want to make sure. And so do you also understand, Mr. Willridge, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence Mr. Willridge is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can just have everything in front of me that I need, make sure there's no other issues, and then we'll go forward with sentencing at that time. Any issue with me releasing Mr. Willridge since he has been doing okay?
No, Judge, if only if wouldn't mind if I just hold on those MTRP dismissals until that sentence
Yeah,
date,
I
just
think
in
that's
case
what makes
something
sense.
pops up.
I think that makes sense. So, Mr. Willridge, what I'm going to do in your case is reduce your bond to $1,000, but I'm going to make that a personal bond. What that means is that you don't have to pay the money. You will be released today. So what I need to do though is, on those motions,
Unless it would make it easier for you if I just dismiss
just
them.
do personal. I can just set personal bonds on all of them. So I'm going to set personal, so on all three cause numbers that you're on probation for, which is 18-28743,
Let me see what we can find on the Philly situation.
18-28744, and 18-30139. I'm going to set bonds on all of those where the motion to revoke are pending at $1,000 also, and make those personal bonds. So what all of this means is that you're going to get out today without paying any money. Some very, very important things though, between now and when you come back for sentencing. Obviously, you're on probation still for the other three. You need to report to probation for two things. One, because you're still on probation. Two, so that they can do that updated pre-sentence report about the new case and kind of how things are going right now. Okay. If you don't go straight to probation when you're released to do all of that, then you run the risk of me not accepting this plea agreement. Things could obviously be much worse. You understand? Speak up, please.
Yes, ma'am.
Also, if you're arrested for anything between now and when you come back, you run the risk of me not accepting this plea agreement, and then you've got those motions pending and things could obviously be a whole lot worse. You understand that as well? And so, was there a co-defendant in the burglary? Or no? Okay.
I don't think so.
So you do, I am going to order as a condition of your bond also, and it will be a condition of your probation that you have absolutely no contact or communication with Jasmine Adams as the owner of that apartment. And that apartment was where? Do we have an address?
That apartment was located.
I can probably get that.
It's 4165 Old Dallin Road. It was apartment 91, but I would suggest.
So,
you stay
yeah,
away from the
so-
entire complex.
Correct. That's what I'm gonna do. So you cannot go anywhere near 4165 Old Dallin Road. Any of it, none of the apartments. Do you understand? Anything else that you feel like I need to order as a condition of the bonds?
I'm just double checking for any type of co-defendant. No, Your Honor, I don't believe so.
Okay. All right, then we'll see you back at sentencing. Again, make sure as soon as you're let out of custody that you go straight to probation. Okay. And then on Jabbar Bell, Mr. Parker.
Just to remind you, you did complete the first two, and the third one you started, we had to do the enhancements.
Okay.
He's already pled guilty, but you're just starting to enhance it.
Thank you. And so did it, it's probably not going to show up. Did you file that through?
I did not, Your Honor. I'm offering it in open court because it was agreed by defense counsel. I've
Okay.
given him an opportunity to review both the motion and the order, which I'll submit to the court at this time.
All right, sir, you're Jabbar Bell again, right?
Yes, ma'am.
And so we're back on cause number 26, DCCR 0274. And in that case, Mr. Bell, I'm going to start from the beginning in that one. You're charged with the state jail felony offense of evading arrest or detention with previous convictions from January 21st of 2026. And the indictment alleges you were previously convicted of evading arrest or detention March 13th of 2017, and then again November 8th of 2021. And how do you plead to that charge? And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
Now, Mr. Parker, the state has filed a motion asking to amend the indictment to include those 2 prior offenses that we've already gone through and read in the other tech cases. Do you have any objections? And you will waive your any time to review that, correct?
Yeah, Judge.
So, Mr. Bell, the indictment, I'm going to grant the motion to amend the indictment. Further shows now that you were arrested or convicted previously of unauthorized use of a vehicle, a state jail felony, June 24th of 2019. And after that was final, you were convicted of burglary of a building, a state jail felony, June 26th of 2023. And are those prior convictions true?
Yes, ma'am.
And in all 3 of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Bell is not competent?
No, Your Honor.
All right, sir, I'm going to find in all of your cases that you entered your pleas of guilty and true, freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of those pleas. And cause number 26, DCCR 0139, find sufficient evidence to find you guilty. And at this time, find you guilty of theft of property with previous convictions. Find all of those prior convictions that you pled true to, true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then, excuse me, clause number 26, BCCR 0140, also find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find all of the prior convictions that you pled true to, true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in clause number 26 DCCR 0274, again, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with previous convictions. Find all of the previous convictions that you pled true to, true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All 3 of these cases will run concurrently, which means together at the same time. And I'm going to hand you in all 3 cases the trial court certifications that shows that these were agreements that I followed, and so you waived any right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. Thank you, Ms. French, for getting that taken care of. And
good luck,
Mr.
sir.
Parker.
Aaron Spencer in Arkansas, late June. What did?
All right, I'm going to take just maybe a 5 or
do?
10 minute break, and we'll get back in and get started on the hearing as quickly as I can. Yeah.
What hearing?
And that is on Louisa McGregor. And what else do I need on that?
She's going to take a little break. Oh, DZN, Disney Babe. There we go. I figured it out. Disney Babe. Tell me a little bit about Aaron Spencer. The name sounds familiar. Sarah Hammer, we're waiting for Texas v. Romeo. Unalived his daughter's abuser. Oh, wow. Maybe. I know it's adjacent to the illicit activities with a minor, which is a really tough thing, and a lot of times, honestly, it's the court has some restrictions in that area where they would limit or prohibit streaming in some situations. But where this is a retaliation trial, that would be interesting. Is he the one who's running for mayor also? I think I heard that. That sounds like, and it's out of Arkansas. Sheriff. He's running for sheriff, and he won. Oh, wow. This is a good one. We'll see if we can put in for that one. I don't know. We'll have to look more at the facts to see, first of all, what the state will allow. He didn't run for sheriff. Is it a different person? He's running for mayor. He's running for mayor. He went after him. So it's like the Liam Neeson trial. But obviously not Liam, like what was that show? Was it Taken? Or he won the preliminary for sheriff. The trial itself, I don't know how much of those illicit that information would come in. There might be some testimony that way. Liam will play him. Disney babe, but you're the first to get my name. I was confused. I'm like DZ New York. Nope, Disney. Found it. Disney. We'll have to watch. I can't commit right now, but we'll have to look at it and watch. Maybe we can fill out some paperwork and try to lay the foundation for going forward that way. I do like a lot of stuff out of Arkansas. I mean, especially the police chases. So maybe their trials would be good as well. It sounds fascinating. He ran and won the primary for sheriff. I wonder if they'll let him run on the. Man, that's crazy. Some crazy stuff. We are waiting for court to start. I think they still have to finish picking a jury in this Romeo case in Texas. We're sort of watching the judge's morning docket as she sort of gets that out of the way. It will probably be after lunch. I'm also looking at an option to be more secure on streaming feeds to me, that it might be even easier for people to connect through. Go to settings. Add outputs. We're going to be in New York. Add to cart. Proceed to cart. What's in my cart? Sure, I'll buy one. I'm going to buy one. We'll see what. I bought one. We'll see how this works. Okay. Streamer output settings. All right. We might have to take a lunch and then come back with the judge afterwards. How can I do this? This little tiny keyboard is defeating me. Hang on one second. There we go. Apparently I need to buy a destination as well. Manage services. Inputs, outputs. Okay, all right, the chairs look fancy. What are we having for lunch? Metal detector isn't even on. Bailiff's just wandering around the courtroom. Did anyone watch this defendant's murder trial? He was acquitted, but his own testimony was why he's back on trial. Oh, man. We did watch the preliminaries a little bit. Let's see who's walking in. Anybody? No, they're not ready. We're going to go to lunch, but I need to set up the portal first. So don't leave yet. Hang on. We'll set up a portal and bring you all over. New York. Account settings, manage services. Echo, 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 echo. Hello. Yeah, that was fun, but now it's done. Okay, I'm just buying stuff and I don't know what it is. I know that's not the right way to do things, but We'll get that sorted out. All right, no car yet. No car yet. Corey Richardson's sentencing will be May 3rd. Delayed, denied. We saw that this morning. That's interesting. I can go to the post office. I can do that as well. Let me finish setting up the portal. We'll come back here in just a second. So, schedule stream. It's going to be Texas v. Romeo. It's still part 1. We'll rename this one because it just never happened. Let's see, we're going to come back. It's 12:30. We're going to come back at 1:30. Give us an hour for lunch. Need to get download the new thumbnail. Thank you, Red, for this one. Looks great. I love it. There we go. New thumbnails down. There it is. Load it up. We're ready. It's done. And portal.
All right, let's go.
Oh, she's back. We have an echo. It's that camera, Judge. It's the witness camera.
When are we going to break for lunch, Judge?
We're going to break for lunch in just a minute. I promise, I promise. All right, it's lunchtime. The judge can't figure out the audio. We can't figure it out either. I'm not sure what I just bought, but I bought 3 of them.
So when I start talking.
Talking. Echo. The bailiff did it, Judge. The bailiff was messing with the buttons while you were gone. Hope this doesn't cause problems for our court coverage today.
How's that?
It's better.
Better.
You watch.
Okay.
Can you
Good.
get this muted? Did I just?
Thank you for the clapping seal, Greeners. Arr. Okay, we're going to go to lunch. I'm sort of waiting to see what this is. If it's interesting, we'll watch it before we leave. But if not, we go to lunch because I'm like hungry, super hungry.
All right, let's go on the record in cause number 16-25158. What witnesses do you expect? Just probation?
Your Honor, it would be Wesley Tucker from probation.
And other than that, that's all we have, correct? Because they're so y'all can come on up. Let's do it up here at the bench.
Good morning, Franklin Bynum from Mr. Bureau. Could I request a court reporter for the hearing?
I have a court reporter.
Okay, great. I didn't see you there. I'm so sorry.
Y'all come on up if you would. Ms. Magruder, come stand on the end. Good morning, ma'am. You're Louisa Magruder?
Yes, ma'am.
And Ms. Magruder's here with her attorney, Mr. Bynum. Ms. French is here on behalf of the state. Ms. Magruder is on probation in cause number 16-25158 for the second-degree felony offense of sexual assault of a child.
Okay.
Was placed on that probation January.
All right, we're going to go ahead and go to lunch. So that was a quick decision. Tiffany, the next trial starts. We're doing the Texas v. Romeo in that judge's courtroom. They're doing jury selection yesterday. We watched a lot of that. It should go on today. He was actually tried for murder, found not guilty, but because of his testimony, He's now being tried for felon in possession of a firearm. So it's his own words that are going to come back to haunt him. We're going to see how that happens. And then after that, we are going up to Ohio for the, what was it? Greeners. The Ohio trial. I'm sorry. Not Karen Reed. No. The other one. I'm waiting. Caleb Flynn. Thank you. Red Pen puts it all in caps. That name does not fit in my brain. I don't know why. It doesn't. We're going to go to lunch and we're going to come back with this trial out of Texas. After this one, we'll do probably a little bit more court hopping. Will get us before we get to Caleb Flynn, which starts soonish. They got a little delay, so it's pushed it back a few days. But we'll have some trials. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe. We go live again in about an hour with some more court coverage out of Texas, as one of our favorite judges deliberates and delivers justice with a jury in this trial. You guys have a great lunch. We'll see you later. Bye-bye.